In the matter of KALLU alias MAYANK Kumar Nagar versus State of Uttar Pradesh, Supreme Court dismissed the petition and said that no error, not to speak of any error of law, can be said to have been committed by High Court in passing impugned order. Trial court shall now proceed to frame charge if not yet framed and start recording with oral evidence of witness. Trial shall be completed within 6 months from this order. The seminal issue that fell for consideration was whether Court of Session, without itself recording evidence, can summon a person to stand trial in exercise of powers under Section 193 of Criminal Procedure Code as accused on basis of materials in form of statements and other documents as contained in final report of investigating officer under Section 173 of CrPC independently of provisions of Section 319 of said code. The court concluded that both under sections 209 and 193 respectively of Code of 1973, commitment is of the case and not of the accused, as distinguished from section 193(3) and section 207A of the old code, where commitment was of accused and not the case. For committing a case, there must be an offense and involvement of person who committed the same. Even though case is committed, yet cognizance taken is of offense and not the offender. Once the case is in respect of the offense qua accused who are before the court is committed and cognizance is taken, embargo under section 193 regarding taking cognizance only by committal goes. Summoning additional persons will then be regarded as incidental to cognizance already taken on committal and as part of normal process that follows. A fresh committal of such person is not necessary. Section 319(4)(b) enacts as deeming provision in that behalf, dispensing with formal committal order by providing that person added will be deemed to have been an accused even when cognizance was taken first. Cognizance is of the offence and not offender, and it is duty of court to find out who the offenders are. Proceedings could be instituted and cognizance taken also against person not known at that time. This is clear if provisions of section 190 of code are read along with definition of complaint in section 2D, which include allegations against unknown person also. Making unknown persons known is therefore within powers of court. When such persons become known by evidence during inquiry or trial, it is not only the right but also duty of court to bring them on record and proceed against them in attempt to bring them to justice. There cannot therefore be any dispute regarding powers of court to bring person under section 319(1). Once the court takes cognizance of offence, not of the offender, it becomes a court's duty to find out real offenders, and if it comes to conclusion that besides persons put up for trial by police, some other persons are also involved in commission of crime, it is court's duty to summon them to stand trial along with those already named, since summoning them would only be part of process taking cognizance. Court explained that position of law is clear that Court of Session has power under section 193 CrPC to summon a person as accused to stand trial even if he has not been charge sheeted by police and whose complexity in the crime appears in the evidence available on record. To hold in such a situation that if investigating agency blatantly exonerates an accused person and magistrate does not consequently commit him, the Court of Session itself would be rendered powerless to put such an offender in the dock at the very opening stage of trial would to the mind of the court only hamper the cause of justice rather than advance it. It is to be borne in mind that herein we are considering procedural provisions, and it is well settled that procedure is handmaid of justice and not to be employed as a roadblock thereto. Therefore, on larger canon of construction, there appears to be no logic for narrowly construing the statute so as to denude the Court of Session of the power to summon a person to stand his trial at the outset, even when wholly convinced of prima facie case against him on basis of materials in final report, which is admittedly adequate for framing a charge against committed accused under Section 228 or discharging him under Section 227 of the Code. On larger principle, one can see no adequate reason to fetter and shackle the power of a superior court, like that of a session court, from summoning a person as additional accused to stand trial when, on the materials before it, it is satisfied that there exists a conclusive or in any case a prima facie case against him. It is for this reason that in Raghuban Dubey's case, the court labeled this power as being virtually coupled with the duty of summoning such an additional accused, and such a power is part and parcel of proceeding initiated by taking cognizance of the offence. The glaring instances necessitating exercise of such power or duty would be when investigating agency in its report under section 173 without any reason or basis whatsoever exonerates a person specifically named in first information report and fully implicated in the crime. Indeed, such an example is provided pertinently in the present case itself. Herein, Court of Session has come to categorical conclusion that petitioner, though not named at the earliest in the FIR, yet the investigation revealed his involvement along with the charge sheeted accused.